Bill C-16 enacted to amend certain acts in relation to criminal and correctional matters is what I'm going to be discussing tonight, including child protection, gender-based violence, and delays and other measures that are part of this bill. It's a broad justice omnibus bill that combines victim protection and criminal law modernization measures, but with a fundamental restructuring of mandatory minimum sentences, and it is a fundamental restructuring. Also, there are some good parts to this. Banning deepfakes of intimate partners will keep Canadians, especially women, safe from non-consensual intimate images being created and shared. I'm thankful the government has adopted the proposal from MP for Calgary-Nose Hill in her Bill C-216 to do exactly that. The bill also criminalizes coercive or controlling conduct within intimate relationships. This is something that I've been very concerned about, and believe that behaviors that have been the precursors to serious injury and death of women in those relationships often happen when women are most vulnerable. And this government has basically failed to mention that this time when women are especially vulnerable is when they are pregnant and expecting a child. Provisions from the same bill to bring in mandatory reporting for child sexual abuse materials have also been taken up, helping our kids feel safe from the most despicable crimes, and hopefully are safer from those crimes. I applaud the member for Kamloops Thompson-Nicola, whose calls have been heard to make the murder of an intimate partner automatically first degree. While the Liberals sadly opposed Member of Parliament for Edmonton Gateway's bill to introduce a 3-year mandatory minimum sentence for all forms of extortion, at the very, very least, C-16 introduces an aggravating factor for sextortion, and it's a step in the right direction, but it's not anywhere near far enough. So there are some good things, but of course, as we're hearing today, there are some very serious concerns, specifically with C-16. Despite these positive additions, C-16 continues the Liberals' very soft on-crime agenda. The bill would empower judges to ignore literally every mandatory prison sentence in the criminal code other than murder and treason. Liberals want to empower judges to ignore mandatory sentences for things like aggravated sexual assault with a gun, human trafficking, multiple violent firearm offences, extortion with a firearm, weapons trafficking, drive-by shootings with a restricted or prohibited firearm. These are some of the things that this government is prepared to declare are not violent crimes worthy of further mandatory sentences. By creating a general safety valve, Bill C-16 introduces a sweeping sentencing change, allowing courts to impose sentences below mandatory minimum capabilities, where applying the minimum would amount to cruel and unusual punishment for the offender. I have nowhere to put this. If mandatory isn't mandatory, then we have an issue with our judicial system being given the opportunity to play around with this. This provision would apply to nearly all mandatory minimum sentences in the criminal code and other federal statutes, effectively converting mandatory minimums from binding sentence floors into discretionary benchmarks. While custodial sentences would still be required, Parliament's ability to set firm baseline consequences for serious violent crimes would be significantly weakened, encouraging lighter sentences for violent and repeat offenders, and the long-term erosion of mandatory minimum sentencing as a policy tool, resulting in more, not less, violent criminal activity on our streets. Victims, advocacy groups, and the federal ombudsperson for victims of crime are in disbelief. In 2021, instead of fulfilling the responsibility to review the Victims' Bill of Rights, as was outlined, the Liberals began a study through the House of Commons Standing Committee on Justice and Human Rights. According to Ombudsman for Victims of Crime, the committee eventually produced a December 2022 report titled Improving Support for Victims of Crimes. Critics, including the ombudsperson, argued that the review was not as comprehensive as the legislation warranted. Although 13 recommendations were made, many of the most significant remain outstanding to this day. The federal ombudsman continues to argue that victims' rights remain largely symbolic rights that are not enforced, and let us comment on the fact that that's what's happening to the victims, but look what's happening in regard to sentencing of those who perform violent crimes against those victims. In 2024, it was stated that many of the recommendations could significantly improve victims' experiences if they were implemented. Many of the more significant recommendations are remaining outstanding. Automated notification of rights. One of the biggest complaints is that victims are still generally required to seek out information themselves. Victims are still not automatically informed of their rights, services, offender statuses, parole processes, and restitution options, and yet the accused are informed of theirs. What is wrong with this scenario? Stronger enforcement of victims' rights. The Canadian Bill of Rights gives victims rights to information and whatnot. However, there's still no broad mechanism allowing them to go to court and obtain a remedy when those rights are violated. National minimum service standards. The committee and ombudsperson called for more consistent national standards, but the government has not provided those national standards, leaving victims to try to navigate services that are significantly significantly between provinces and territories. Why? Why has the Liberal government treated the Victims' Bill of Rights as largely symbolic and has failed to strengthen victims' rights in a meaningful way? While instead, why are victims seeing the insertion of this poison pill in the form of a safety valve in C-16 dangerously weakening Liberal criminal justice policies, giving more leniency towards criminals in their sentencing reforms? That is what is happening here. This poison pill is antithetical to preventing violent crimes. It is giving more leniency. There should be one track in this bill, C-16, for victim protection, coercive control, deepfake offences, and trial efficiency measures. It is so typical of this federal government to bring forward a bill that, quite honestly, they know so much of it even was put forward by our members, and yet they put something in there that is so antithetical to the goodness that could be done on behalf of victims and to lessen the amount of violent crime that continues to grow in this country because of the laws that they have allowed to take place, such as bail and not jail, and lowering the sentencing requirements for those who are committing very serious violent crimes. This would allow each component to be studied on its merits. Let's study this bill separately from this desire that they have to basically remove mandatory minimums from our judicial system. We would be able to support the victim protection and procedural component of Bill C-16. But the mandatory minimum sentencing safety valve is definitely something that should not be part of this bill. Why does it even matter? Parliament sets mandatory minimum sentences for these heinous crimes for a reason. If the Liberals allow judges to ignore them, there will be nothing mandatory about it. Even though the vast number of mandatory minimum sentences have already been deemed constitutional, and now they are putting them in jeopardy when they have already passed that test of constitutionality. They are allowing judicial activism. As a matter of fact, they're encouraging it towards lesser sentencing. And on top of that, they're using hypotheticals rather than the real situation in front of them to make decisions that are actually causing more harm to victims and creating more violent crime in our country. The court's responsibility is to interpret and use these laws created by parliamentarians that are in the best interests of those who face the terrible conditions of violent crime, and we've heard about many of those today. We continue to see the erosion of Canadian safety when criminals' rights are put ahead of victims' rights, and this is part of the problem with this approach to the Charter. We have already indicated that the vast number of mandatory minimum sentences have been deemed constitutional, and yet this government is giving the judicial system, an activist judicial system, a window to go out and make huge changes to that. The passage of this provision will be a total abolition of our duty as elected representatives to keep Canadians and their communities safe. The Liberals should split this poison pill out of this bill so that parliamentarians can work together to pass C-16. Thank you, Mr. Speaker.
Questions and comments, questions et commentaires. The Honourable Secretary of State for Combating Crime. Mr. Speaker, I've met many victims across this country and families that have lost loved ones to femicide, and they are very eager to see this bill pass forward. And, there's been a lot of cooperation at the committee level and amendments that have been accepted, some were outside of the scope, however. And I really wanted to know whether the Conservatives will be supporting this bill that is the largest change and protection to women's rights and the rights of children.
Honourable Member for Yorkton Melville.
I have to say I was really pleased to see some of the items that are in this bill in regards to protecting women when they are being attacked. And I actually am a little surprised because this government, when it has had opportunities to support bills, two of them mine, private members' bills, that give protections to women and to recognize when they have been attacked simply because they are pregnant, or in a case where the attacker, a third party, knows that they're pregnant and there was no recognition at all of that circumstance for them, and I call that a poor failure on the part of this government.
Questions and comments? Questions et commentaires.
The Honourable Member for Abitibi-Témiscamingue. Thank you, Mr. Speaker. I'd like to thank my colleague for her speech. In the research I've done, I realized that my riding, in 2023, there were 2 trials that were halted because they apparently used defense procedures under the Jordan rule. It had to be applied. Is that not an issue? Is there a lack of resources? And does this bill, at the end of the day, help solve this, or does it just leave victims to fend for themselves? And is there a lack of justice because of a lack of resources?
Melville.
No victim should face a situation where they don't get justice from our courts. And it is very frustrating to see the limitations in a lot of ways of our court systems. At the same time, I am really frustrated with the fact that this federal government continues to pass the buck to our provinces. I know that the circumstances, as the one member was saying, we have growth in populations, we have immigration that has gone far beyond our capacity as a country to be able to handle with schooling, with housing, with jobs, with education. I would say also with dealing with individuals who come to our country who perhaps are adding to the challenge of getting those court systems through all of their cases.
Questions and comments? Questions et commentaires. The Honourable Member for Vernon Lake Country, Monashee.
Thank you, Mr. Speaker, and I thank my colleague for the speech she gave. My colleague spoke about the poison pill. And first of all, mandatory sentences, obviously, as my other colleague pointed out much earlier, do in fact stop crime, because it's very hard to commit crime when you're in jail. So, as far as minimum sentences go, as far as the poison pill goes, when I raise my kids, and I tell them to clean the room, or I did tell them, they're grown up now. When I told them to clean the room, I didn't add at the end of it, unless you don't feel like it. And this, I believe, is what is happening with this bill, is you've got to, if you don't feel like it, you don't have to obey the law. I'd like my colleague to expand on that if she would.
Yorkton Melville.
For that observation and for that question. Well, that is part of the problem that we have here when you have a government that has introduced over this last 5 years to 10 years bills that basically give leniency, more and more leniency to the expectations of citizens and people who are in our country to obey the laws of our land and to treat other people with respect and not create scenarios where violence is allowed. It's not only allowed, it seems to be encouraged. And a poison pill is something that we use in this House to describe the Liberal government's legislations over and over and over again. As a matter of fact, my constituents are starting to use this term because they see the good in a bill, but then they see and they're recognizing where something has been interjected that is contrary to the value of that bill and is going to actually harm citizens rather than protect them. Thank you.